Be ready? Start. These appeals have been filed against the impugned judgment of the Andhra Pradesh High Court dated 30/4/2003 in writ appeal number 629 of 2003 and writ appeal number 584 of 2003. Stop. For the sake of convenience, we will deal with the facts of civil appeal. Stop. Heard learned counsel for the parties and perused the record. Stop. The facts of the case are that the respondents 1 and 2 in this appeal were appointed by the Andhra Pradesh State Road Transport Corporation, hereinafter referred to as the corporation, as contract sweeper and attend on 1/5/1992, and respondent number 3 was appointed as such on 1/8/1992. Stop. They submitted representations to appellant number 1 and 2 for regularization of their services, claiming that they have completed 240 days of continuous service without any break, but since 10/5/1998 the appellants were not giving them work. Stop. Hence the respondents filed a writ petition, being writ petition number 10678 of 1996, which was disposed of by the High Court on 17/10/1997, directing the corporation to consider the case of these employees for regularization of service. Stop. Stanza. By order dated 31/3/1998, the representation of the writ petitioners was rejected on the ground that their regularization can only be considered when they are recruited through the prescribed departmental selection committee and after undergoing a selection process. Stop. Since they were not selected and appointed in accordance with the aforesaid procedure, their case for regularization could not be considered. Stop. Aggrieved, the respondents filed a writ appeal number 6948 of 1999, which was allowed by a learned single judge of the High Court. Stop. Stanza. In the counter affidavit filed by the corporation in the writ petition, it was stated that the petitioners were entrusted the work of the attendant sweeper on casual basis on a consolidated pay drawn through a pay order on certification of the work every month, but they were not issued any appointment order. Stop. It was also submitted that as per the circular of the corporation dated 1/5/1996, there was no provision to engage anyone on contract basis or on consolidated pay. Stop. The writ petitioner had not undergone the departmental selection process, and as such they were not entitled for regularization. Stop. Learned counsel for the writ petitioner relied on the circular of the corporation dated 26/10/1988, wherein guidelines were issued to engage the existing contract labor such as cleaners, including piecemeal rated labor, against the sanctioned vacancies. Stop. In view of this circular, it was contended that the writ petitioners were entitled for regularization. Stop. The learned single judge allowed the writ petition and directed regularization of the writ petitioners within 6 weeks. Stop. Aggrieved, the corporation filed an appeal before the division bench of the High Court, which was rejected by the impugned judgment. Stop. Stanza. In our opinion, these appeals have to be allowed. Stop. It has been held by a constitution bench of this court in Secretary State of Karnataka and others versus Uma Devi and others that absorption, regularization or permanent continuance of temporary, contractual, casual, daily wage or ad hoc employees dehors the rules and constitutional scheme of public employment cannot be granted by the courts. Stop. As regards the circular dated 31/3/1998, the same cannot override Article 16 of the Constitution, and hence regularization cannot be granted under the said circular. Stop. Stanza. Challenge in this appeal is to the order passed by a division bench of the Punjab and Haryana High Court allowing the writ petition filed by the respondent number 7, Daljit Singh, purportedly in public interest as a public interest litigation. Stop. Respondents 1 to 6 were official respondents in the writ petition stop. Grievance in the writ petition was that the appellant had got appointment as audit inspector cooperative societies Firozpur on the basis of scheduled caste certificate, though she was not member of any scheduled caste stop. It was averred that the appellant was married to Sri Jagminder Singh, member of the scheduled caste, and it was on that basis aforesaid certificate had been obtained. Stop. It was stated that in spite of several complaints made to the authorities, no effective action was taken. Stop. The official respondents filed a reply to the effect that proceedings to cancel the scheduled caste certificate were under progress and therefore the writ petition was premature. Stop. The appellant filed a written statement stating that on account of her marriage with Jagminder Singh, she was to be considered as a member of the scheduled caste. Stop. It was pointed out that the writ petitioner was not qualified and only because of personal vendetta he had filed the writ petition styled as a PIL. Stop. The High Court, by the impugned judgment, issued a writ in the nature of quo warranto, setting aside the appointment of the appellant. Stop. In support of the appeal, learned counsel for the appellant submitted that in service matters PIL is not maintainable. Stop. The writ petition was filed because of personal animosity and can by no stretch of imagination be considered to be a public interest litigation. Stop. Learned counsel for the respondent number 7, on the other hand, submitted that since the appellant was not entitled to a certificate to the effect that she belonged to any scheduled caste, the authorities were bound to take action on his grievances. Stop. Stanza. The scope of entertaining a petition styled as public interest litigation locus standi of the petitioner, particularly in matters involving service of an employee, has been examined by this court in various cases. Stop. The court has to be satisfied about the credentials of the applicant, the prima facie correctness or nature of information given by him, the information being not vague and indefinite. Stop. The information should show gravity and seriousness involved. Stop. Correct has to strike balance between two conflicting interests. Nobody should be allowed to indulge in wild and reckless allegations besmirching the character of others and avoidance of public mischief, and to avoid mischievous petitions seeking to assail for oblique motives justifiable executive actions. Stop. In such case, however, the court cannot afford to be liberal. Stop. It has to be extremely careful to see that under the guise of redressing a public grievance, it does not encroach upon the sphere reserved by the Constitution to the executive and the legislature. Stop. The court has to act ruthlessly while dealing with impostors and busy bodies as public spirited holy men. Stop. They masquerade as a crusader of justice. Stop. Though they have no interest of the public or even of their own to protect. Stop. Courts must do justice by promotion of good faith and prevent law from crafty invasions. Stop. Courts must maintain the social balance by interfering where necessary for the sake of justice and refuse to interfere where it is against the social interest and public good. Stop. Stanza. No litigant has a right to unlimited drought on the court time and public money in order to get his affairs settled in the manner as he wishes. Stop. Easy access to justice should not be misused as a license to file misconceived and frivolous petitions. Stop. Today, people rush to courts to file cases in profusion under this attractive name of public interest. Stop. They must inspire confidence in courts and among the public. Stop. Stanza. Time has come to weed out the petitions, which, though titled as public interest litigations, are in essence something else. Stop. It is shocking to note that courts are flooded with stop over.